Hello and welcome to Courts This Week by LiveLaw. I'm Debojeet and Happy New Year to everyone watching and welcome to 2026. We're kicking off this year with a packed week in courtrooms across the country. Joining me is Advocate Awstika, who's here to walk us through the key legal developments and what they really mean. This is easily one of the most closely watched Supreme Court judgments in recent years. The court has denied bail to Umar Khalid and Sharjeel Imam in Delhi Riot's larger conspiracy case while granting bail to 5 others. Awstika, what is the core legal reasoning here?
The court has taken a very role-specific approach. It says Umar Khalid and Sharjeel Imam stand on a different footing from the others. According to the prosecution material, they're not being seen as on-ground participants, but as people who were allegedly involved at the level of planning, mobilization, and strategy. The others, the court says, had more local or facilitative roles, which is why bail has been granted to them.
And legally, what was the standard that court was applying?
So this was a bail hearing under the UAPA or Unlawful Activities Prevention Act. So the court was clear that it cannot weigh defense arguments or conduct a mini trial. The test is a narrow one, whether the prosecution material taken at face value makes out a prima facie case. For Khalid and Imam, the court felt that threshold was crossed, especially in light of section 43D5 of the UAPA.
One part of the judgment that's getting a lot of attention is how the court has read the idea of a terrorist act.
The court has interpreted section 15 of the UAPA broadly, saying it's not limited to conventional violence. It can also include acts that disrupt essential services or destabilize civic life. On that reasoning, the alleged planning of large-scale chakka jams was treated as potentially falling within the statutory definition. The court hasn't decided guilt, and this is important to note, but it has said this interpretation is sufficient for the purpose of bail.
At the same time, there's been a lot of talk about them spending so much time in custody.
That's where the debate really is. Khalid and Imam have been in jail for over 5 years and the trial hasn't even begun yet. The court has said that delay by itself cannot automatically override the UAPA's bail bar, though it did leave the door open for them to renew their bail pleas later. Interestingly, just a day after this judgment, a coordinate bench of the Supreme Court, while granting bail in a money laundering case under the PMLA, another special statute with similarly restrictive bail provisions, reiterated that the right to a speedy trial under Article 21 isn't defeated by the gravity of the offence and that prolonged pre-trial detention can itself become punitive. This is why some critics have commented on how this judgment in Umar Khalid and Sharjeel Imam's case seems to take a step back when you compare it with other rulings of the Supreme Court.
So where does that leave things here?
For now, the judgment reinforces how high the bail threshold is under the UAPA, especially for those accused of being at the top of an alleged conspiracy. However, Khalid and Imam, like I said, have been told they can renew bail either after protected witnesses are examined or after 1 year, which critics are saying is one too many years spent in jail as an under trial prisoner in a case where the trial hasn't even begun. And for the 5 who got bail, that freedom has come with very stringent conditions. Staying in Delhi, regular police reporting, no public meetings, no posts about the case, no rallies. The real test going forward will be how quickly the trial moves, because ultimately prolonged incarceration without trial is where constitutional questions become the hardest to answer.
Another important case the Supreme Court heard this week involves the preventive detention of climate activist Sonam Wangchuk under the National Security Act. Awstika, what is exactly the case here?
At its core, this is about whether the state followed the bare minimum constitutional safeguards that apply to preventive detention. Sonam Wangchuk has been in detention since September 26, 2025, so for over 3 months now, and his wife, Dr. Gitanjali Angmo, has approached the Supreme Court saying she was not even given the grounds on which she was detained, making it almost impossible to challenge that detention.
And that's a serious issue in detention law, right?
Absolutely. Preventive detention is already an exception to the normal criminal process in as much as detention is not based on trial or even the registration of a complaint or FIR. So the law is very clear. The grounds of detention must be shared quickly and fully. Here, Dr. Angmo told the court that she had no access to those grounds, and even when Wangchuk's brother met him in jail, it was through a glass partition. So realistically, there was no way for the family to even understand why he was being detained, let alone challenge it.
And what did Dr. Angmo's lawyer, Kapil Sibal, focus on during this week's hearing?
2 things stood out. One, that key material, including videos the authorities relied on, was either not supplied or supplied very late. And 2, that a crucial video where Wangchuk actually appeals for peace after violence broke out was never placed before the detaining authority. Sybil played that video in open court to show that it completely undercuts the allegation that he was provoking violence, which forms the basis of his preventive detention.
So how does the law come down on this here?
The Supreme Court has consistently said that communicating the grounds of detention is not a formality. It's what makes the right to challenge detention real under Article 21. Recent judgments have even said that families must have access to this information because a person in custody can't effectively defend themselves. The judges here are clearly testing whether these safeguards were genuinely followed. For now, the judges have watched the video Mr. Sybil played in court, and the hearing will continue next week.
Our next story today is from the Pune Porsche hit and run case, which shocked the country last year. The Supreme Court has now stepped in on the bail pleas of two businessmen accused of tampering with evidence. Awstika, what happened here?
So the Supreme Court has issued notice on the bail pleas of Ashish Mittal and Aditya Sood. These two are not accused in the accident itself, but in what followed. The allegation is very serious that they helped replace blood samples to falsely show that the minors in the car were not drunk, effectively shielding the juvenile driver.
And the Bombay High Court had already refused bail to them, right?
Yeah. The High Court took a very strong view, saying that there was a clear prima facie conspiracy to tamper with crucial evidence, blood samples, medical records, and even hospital registers, and that this was done to derail the investigation. The court stressed that evidence is the backbone of criminal justice, and interfering with it strikes at the system itself.
And what will the Supreme Court look at now?
At this stage, the Supreme Court hasn't expressed any view on bail. It has simply agreed to hear the pleas. The core question will be whether continued custody is justified, balanced against the seriousness of the alleged offense, especially evidence tampering, which courts treat as extremely grave because it affects not just this case, but public confidence in justice itself.
Next, we turn to a story that's clearly going to shape the run-up to the 2026 West Bengal Assembly elections. TMC MP Derek O'Brien has moved the Supreme Court over the special intensive revision of electoral rolls in the state. Awstika, what's really at stake here?
At its heart, this is about how the voter verification exercise has been carried out. Derek O'Brien is alleging that the SIR process in West Bengal has slipped into procedural chaos, with instructions being passed to booth-level officers over WhatsApp, valid documents being rejected, and new categories like logical discrepancies being introduced without any clear written framework.
And those logical discrepancies have become a flashpoint politically as well.
Very much so. The concern is scale and opacity. According to the petition, around 1.36 crore voters could be flagged based on algorithm-driven mismatches, which includes spelling variations, age entries, parental details, without voters being clearly told what's wrong or how to fix it. That anxiety spilled into the public domain this week when even Nobel laureate Amartya Sen received a notice triggering sharp reactions from the Congress and the Trinamool Congress, who called the process arbitrary and humiliating.
And the Election Commission has pushed back on that though.
Yes. The Bengal CEO clarified that the notice to Amartya Sen was system-generated like other cases, that it related to a technical age-linking issue, and that officials visited his residence and resolved it given his age. Similar explanations were offered in cases involving cricketer Mohammad Shami, who also received a notice as well.
So what is Derek O'Brien asking the Supreme Court to do?
Basically, he's asking the court to slow down the process, put some basic guardrails back in place. That means extending deadlines, pausing the exercise until proper safeguards are set, stopping this practice of sending instructions over WhatsApp, letting booth-level agents actually help voters, and accepting a wider range of residence documents, especially so elderly people, persons with disabilities, and migrant voters don't end up being excluded just because the system could not process them. All of this, of course, is in the context of over 58 lakh voters being dropped from the draft rolls after the SIR.
Meanwhile, the Supreme Court is also hearing pleas against the special intensive revision exercise in other places, most notably in Bihar. What is happening in the Bihar SIR matter?
So to give you a quick one-line summary of what happened in the Bihar matter this week, the Election Commission told the Supreme Court that the Constitution is citizen-centric and that it has, meaning that ECI has a duty to make sure non-citizens don't remain on the voter roll, while also insisting that this isn't some backdoor NRC.
So what I'm hearing is that in all these matters, the court is now trying to balance two very real concerns at the same time, keeping the rolls clean, but also making sure the process is fair, transparent, and doesn't end up disenfranchising people.
Exactly. And in an election year, that balance becomes especially important because public trust in the process really matters.
Our next story was one of the longest and honestly one of the most revealing hearings of the week. The Supreme Court spent hours on India's stray dog crisis, and what unfolded was a courtroom where safety concerns, compassion, and frustration all collided. Awstika, what really stood out for you here?
What stood out was the exasperation across the board, not with community dogs per se, but with years and years of municipal inertia and non-implementation of animal birth control rules. At the same time, some of the exchanges reflected just how emotionally charged this issue has become, even inside the courtroom. The judges kept coming back to the issue of safety in sensitive spaces like schools and hospitals, raising concerns about not just dog bites, but basically what they perceive as unpredictability. At one point, Justice Vikramnath also claimed that dogs can sense fear and are likely to bite someone who's been bitten before.
But the courtroom wasn't speaking in just one voice.
Not at all. Animal welfare groups pushed back strongly against what they felt was a fear-only framing. Lawyers like C.U. Singh and Shyam Devan emphasized that sterilization and vaccination is still the globally accepted approach. They warned that moving towards large-scale confinement or removal without infrastructure could backfire. Importantly, they pointed to a funding gap of nearly 26,800 crore and an estimated need for over 90,000 shelters if dogs were to be housed en masse. Alternatives were proposed by institutions like NALSAR, IIT Delhi, and even Delhi University law students in the form of working examples, showing that when dogs are identified, sterilized, vaccinated, and monitored, conflict drops dramatically. IIT Delhi's microchipping model was cited as having almost eliminated pack aggression without relocating dogs or locking them away.
So they argued that solutions exist but require effort.
Exactly, and that's where the contrast becomes sharp. While some judicial comments lean towards frustration or even sarcasm, like suggestions about counseling dogs not to bite, the other side argued that data on record showed that the real failure is administrative. Experts repeatedly warned that mass removals or overcrowded shelters without infrastructure could actually worsen disease and public safety.
And there was also the issue of dog feeders, especially women.
Yes, but while the court was unequivocal that harassment or violence against women feeders or any feeders is a criminal offense, it refused to let vigilante behavior be folded into this stray dog debate itself.
So where does this leave us with the larger issue here?
The hearing continues, so we'll have to wait for the final outcome. But Debojeet, one thing is clear for me. Community dogs have not created this crisis. What has led to this tipping point is decades of non-implementation of existing rules by municipal authorities. So the framing of the sides as dog lovers and dog haters seems to me like an oversimplification of a complex problem, and ultimately the hope is that the Supreme Court will also repel any attempts to let fear-driven narratives overshadow workable, humane solutions and make the state do the hard, unglamorous work of implementing the law while keeping both animal welfare and human safety in view.
Next, we turn to a story that sits right at the intersection of law, adolescence, and real life. The Supreme Court has asked the union government to think about adding a Romeo-Juliet clause to the Pocso Act. Awstika, what are the judges really getting at here?
So the starting point is how Pocso works today. The law says that if anyone involved in a sexual relationship is below 18, it's automatically treated as an offense, full stop. It does not matter if the relationship is consensual and if both people are teenagers and close in age. Legally, consent just doesn't count when someone is under 18. What the Supreme Court is now saying is this can lead to very harsh outcomes. Teenagers in consensual relationships end up facing serious criminal charges, sometimes because of family disapproval, sometimes after a breakup, even when there's no exploitation involved. These observations came in a case from Uttar Pradesh where the court was dealing with a consensual adolescent relationship and noticed a broader pattern of Pocso being used in ways the law was never meant for.
So where does this Romeo-Juliet clause come in?
In simple terms, it's a safety valve. And the name comes from Shakespeare's Romeo and Juliet, young lovers caught on the wrong side of rigid rules. In many countries, there's an exception in the law that says if two adolescents are close in age and the relationship is consensual, it shouldn't be treated like a serious sexual offense. So, for example, a 16-year-old and a 17-year-old would not be pushed into the criminal justice system for what is essentially a teenage relationship. The Supreme Court is not saying lower the age of consent. It's saying something more nuanced, that the law should recognize the difference between abuse and normal adolescent behavior.
That is an important distinction.
Exactly. The judges were very clear that Pocso is meant to protect children from exploitation and harm, not to turn young people into accused persons for consensual relationships. Right now, the law does not draw that line well, and the court is asking Parliament to think seriously about fixing that gap.
Has the government said anything yet?
Not yet. At this stage, these are strong observations from the court, not a direction. But when the Supreme Court speaks this clearly about unintended consequences of a law, it usually signals that a rethink is overdue. Whether the union acts on it now is something we'll have to wait and watch.
Our last story today starts with a fairly local dispute, but it's grown into something much bigger. A conversation about judicial independence and how judges are treated when they pass uncomfortable orders. This week, the Madras High Court's Madurai bench ruled in the Thiruparankundaram Deepam case. Awstika, what did the court say?
So, Debojeet, a division bench of Justices G. Jayachandran and K. Ramakrishnan upheld an earlier order allowing the Kartikaya Deepam lamp to be lit on the ancient stone pillar, the Deepathun, on Thiruparankundaram hill near a dargah. What really stood out was how strongly the judges pushed back on the state's law and order argument. They called it an imaginary ghost and said quite plainly that any disturbance would happen only if the state itself allowed it to happen.
That's unusually blunt language for a court.
It really is, and it makes more sense when you see the background. This case began with an order by Justice G.R. Swaminathan, who had allowed the lamp to be lit and later came down hard on the administration for simply not implementing his directions. He even said that if officials wouldn't act, devotees could go ahead and light the lamp themselves with security protection. That firm stance is what triggered a political storm, including an impeachment motion against him in Parliament.
Which then drew that rare statement from former judges.
56 former judges stepped in and said this crosses a line because judges can't be threatened with impeachment just because their orders are inconvenient or controversial. But when the division bench decided this appeal, it stuck strictly to the law. No agama prohibition was shown, there was no bar of res judicata, and ASI rules can manage the logistics.
So in a way, this judgment is about more than one lamp.
Or one religious rite. At one level, it is a dispute about a religious practice at a specific site. But at another level, it's about whether courts are allowed to do their job without fear. When you place this alongside other recent movements, judges being subjected to attempted attacks, pressured or second-guessed, it becomes clear why this case matters. It's a quiet but important reminder that the rule of law depends on judges being able to decide freely, even when the decision makes people uncomfortable.
That's a wrap on the major courtroom developments this week. We'll continue to follow these cases closely and break down what lies ahead with Advocate Awstika Das here. Thanks for watching Courts This Week. See you next time.